So do we need a cooling off period for judges before they take post-retirement sinecures like governorships? That's the question I want to raise. I'm joined by three senior advocates. Aman Lekhi, Senior Advocate, Supreme Court, former Additional Solicitor General of India, CA Sundaram, Aryama Sundaram, and Vishwajit Bhattacharya, also a former Additional Solicitor General. Appreciate all of you joining us. Want to get each of your remarks to this. Start with you, Aryama Sundaram. Do you believe that someone who has just retired 5 weeks ago should accept the governorship of a state? Won't it be seen in perceptional terms as some kind, as the opposition is calling it, a post-retirement benefit, a gift?
I do not see it that way, Rajdeep, and let me tell you why I don't see it that way. Whether the office had been given now, 6 months later, 1 year later, the opposition would find reason to do so, to contradict it, to criticize it. That is the job of the opposition. Political science demands that the opposition will criticize the government and will take any step possible to attack the government, quite forgetting that that very opposition, when they were ruling, may have done the very same thing. But let me cut the wheat from the chaff, the grain from the chaff, and come down to the point. What is wrong in what has been done? You have enough faith in the person that without fear or favor, he will uphold his constitutional office as a judge. He has an impeccable reputation. There is nothing said about him in person, but what is sought to be raised is an academic issue as to whether it should be permitted or not. My answer to that is very simple. A Supreme Court judge is a constitutional appointment. He is technically, in the simple sense of the word, literally literal sense of the word, he's not a government servant. He is actually a constitutional appointment. He takes that appointment to discharge his functions without fear or favor. He becomes a governor. The moment you criticize his becoming a governor, you indirectly are saying, oh my God, does that mean when he was sitting as a judge, he gave erroneous judgments, that those judgments were given with fear, with favor? Now, if none of his judgments can point to that, if never when he sat as a judge did you ever have anything to say against it, why should this taking up of an office where constitutionally our constitutional forefathers saw that office of a governor as an elder, as a senior statesman, a person to guide and show, not get involved in the daily political matters? Constitutionally, the governor's powers are only to abide by the aid and advice of the Council of Ministers. When areas of breakdown, he's meant to apply the Constitution. Why would a Supreme Court judge with his knowledge of the Constitution not be very good to hold that office?
Should there not be a cooling off? No, you're not.
He must have done something as a sitting judge, which I think is uncalled for.
In the absence of a cooling off period, Aryama Sundaram, a perception can be built.
Let me explain to you why. Look, there is a basic error made in two things. One, so far as the tribunals, Human Rights Commission, the Company Law Tribunal, the National Green Tribunal, Human Rights Commission, everything, forget it. There is no cooling off period, nor can there be, because those enactments, those legislations which create those bodies mandate that a judge, either the retired Chief Justice, or retired judge of the Supreme Court, or retired Chief Justice of India will be the chairman. So that is different. We are talking about a governor. That's a different issue. There, I believe, the moment you say a cooling off period is required, you are not saying the man is not fit for the office. You are saying, let him wait for some time before he takes the office, because you want to assuage all feelings and make people feel it's okay, it's only after 6 months, public memory is forgotten, so therefore it is not a quid pro quo. Otherwise, people might think it's a quid pro quo. My point is, there's a basic fallacy. If you say that his appointment after 2 months should not have been there because it's a quid pro quo, why would after 6 months not be said to be the same thing? The point is, an opposition politically, whichever party is there, will criticize. And they will do so whenever the appointment takes place.
Vishwajit Bhattacharya, you want to respond to what Aryama Sundaram says. He says, what difference does it make, 1 year, 2 year cooling off period? You know, if the judge is good enough to be a governor, so be it.
I have very serious reservations of a former Supreme Court judge to take up the office of a governor. A governor holds the office during the pleasure of the President under Article 156(1) of the Constitution of India. And the pleasure of the President disappears with the change in government. So it is an out and out political appointment. And when Supreme Court and particularly
The Constitution, Mr. Vishwajit Bhattacharya, there is nothing in the Constitution that debars a Supreme Court judge from becoming a governor. We've had instances in the past. Fatima Bibi became, we've had Sadasivam become. So, why is it now that we must raise this issue? Either we change the Constitution and make it constitutionally impossible for a former Supreme Court judge to become a governor.
100 wrongs cannot justify another wrong. Every time you go back and switch back and go back to the ghost of whatever has happened in the dead past. Let the dead past bury its dead. Let India shine from the morning dawn. Rajdeep, you must remember that Supreme Court is day in and day out standing as a match referee in this political slugfest. And if the impression gains ground that the match referee appears to be siding one of the players in the match, then that's the end of the public faith in the public faith in the institution of the judiciary. Justice must not only be done, and I wish Justice Abdul Nazeer will set a new benchmark by declining the appointment. It is time all Supreme Court judges must unite and save and protect the common man and public's faith in the institution.
Okay, you're saying
Supreme Court is acting as a match referee, and referee cannot be afforded to be seen as having taken a side of a match.
I've taken your point, sir.
Otherwise, that's the end of the match.
Okay, I've taken your point. Aman Lekhi, where do you stand on this? Do you believe Justice Nazeer should decline in the interests of propriety? Within a month of having retired, he's become a governor. He could turn around and say, look at former Chief Justice Ranjan Gogoi, he became a Rajya Sabha MP.
Well, I find this utterly disagreeable. I find it lacking in rectitude and lacking in decorum, constitutional decorum. You're talking about earlier instances. When you talk about earlier instances, you don't talk of them as precedents. You deal with them as conventions. And when you deal with conventions, it's not the number, but the normative worth of the convention that matters. Merely because the wrong has been committed earlier doesn't necessarily mean it will be continued into the future. We are dealing with the Supreme Court judge, and with utmost respect, I disagree with Mr. Sundaram over here. It's a question of perception. You have people over here, I don't join the chorus in which they discredit the earlier Supreme Court judgments, but the point is that the critics get a chance to comment upon the judgments and suggest that some kind of backroom dealing as to bring the judgments about.
So there should be a cooling off period? In your view, should there be a cooling off period?
I personally, ideally, I feel the judges should not take up an appointment like this. That's an ideal scenario. But the point is that presuming the appointments that we made, there has to be a cooling off period. That's absolutely imperative because it is necessary to bring about a gap between the judicial office and the appointment so as to make sure that there is no quid pro quo behind the appointment, and the revolving door in politics has necessarily to be avoided. Otherwise, as in the case of bureaucracy, of regulatory capture, there can be political capture of the court. And judgments, as I always say, should not be reduced into political capital. And the vulnerability right now is the comments which are coming in this regard, which can easily be avoided.
Okay, let me just play as I conclude. I wish we had more time, and we will raise this. What Arun Jaitley, former law minister himself, a distinguished Supreme Court advocate as well, when he was in the opposition, had to say. Maybe Kiran Rejuju should listen in to one of his predecessors. Listen in to what Mr. Jaitley says as I thank my panelists. Take a look.
Desire of a post-retirement job influences pre-retirement judgments. It's a threat to the independence of judiciary. And once it influences pre-retirement judgments, it adversely impacts on the functioning of our judiciary itself.
Old political jungle saying, where you stand on an issue depends on where you sit. You say one thing in the opposition, you say the other thing when you're in government.